Hi friends, attorney Deniz here. Today I'm going to talk to you about a precedent case regarding arrests for marijuana here in Florida. This case has changed the game. So let's talk a little bit about this case. Basically, this individual was applying for cancellation of removal. It was denied at the immigration court. Later, he appealed. The Board of Immigration Appeals also denied it. So he took it to the higher court, the 11th Circuit. Now, this individual was applying for cancellation of removal. This is a special law that allows you to apply if you've had continuous residence for a certain number of years and you don't have an aggravated felony. This is a shortened version because it has a lot more requirements, okay? The law mandates certain events that can cut off your continuous presence. Among the reasons that they can use to cut off your continuous presence so that you don't qualify to even apply is that you've committed a controlled substance violation. Now here's where it gets interesting. The state of Florida defines marijuana as containing all parts. I'm not going to get into the definition because it's very detailed and long, and all you need to know for this purpose is that along the years, basically, the Immigration Court and the Board of Immigration Appeals have said that the Florida definition of marijuana is close enough to the federal definition, and therefore, people should be deported or not granted their relief. To make the long story short, the 11th Circuit says that when the statute is clear, and this is a principle that we are taught in law school, this is something that is fundamental. When the statute is clear and unambiguous, courts will not look behind the simple language to interpret the legislative intent. The 11th Circuit concludes that the Immigration Court and the Board of Appeals were wrong in deciding that this man did not qualify for cancellation of removal. Because by the simple language of the statute, not all the substances found in it are prohibited. The stems and the fibers produced from the stems are not prohibited on the federal level. Now, this is the best part of the case. This is where the 11th Circuit basically takes the samurai sword and digs it in. This was so enjoyable for me. I mean, it's so good. They say to the immigration courts, although the BIA and the IJ conclude that the definition of Florida did not diverge to any significant degree, our court generally does not ignore the statutory text and construct a narrower statute than the plain language it supports. In layman's terms, they basically told them, even though you choose or have chosen to ignore the plain statute all these years, we're not going to do that because that's wrong to do. So what does this mean for you if you have an arrest relating to a controlled substance and specifically marijuana? This means that now you have a new argument, a new solution. If you haven't started your case yet and you haven't done so out of fear, there's hope now. Contact us to discuss your particular case on 833-206-4472, and we would be so happy to help you investigate how this new case can change your life. Until next time, friends.